Did everybody have a chance to look through at least a few of those? So on the first one, 1A is improper use because it says order Mr. Ribs for dinner. It's not being used as an adjective. On the right it is. It says order Mr. Ribs baby back ribs for dinner. Number 2A is not a proper use, again because it's not being used as an adjective. Even so they put the TM on there, it still says order Mr. Ribs for dinner. Proper use would be order Mr. Ribs, TM baby rat ribs for dinner. 3B is improper because it's, let's see here, because they put an SM which designates service mark, but it's for a product because it says order Mr. Ribs ribs for dinner. So it's not the restaurant services. If it was restaurant services, that would be fine, service mark, but it's for the product ribs. 4A says only use then circle R if it's registered. So order Mr. Ribs for dinner. If they have not registered that, they should not be using then circle R if they do not have a federal trademark registration. And then 5B, it's improper because TM is not, you can use TM to designate a service mark, but it's better to use SM to designate it as a service mark. Because here they're not talking about the product, the rib product, they're talking about the carry-out service.
What does TM stand for again?
Trademark and service mark. And
so they really should register both if they're going to have home delivery.
Right, and you'd have to register that probably in 2 separate classes if you registered it federally. And then 6B is improper because they don't have a TM or an SM, so you don't know what they're doing.
Mm-hmm.
Any questions on any of those?
So 4A was not proper, even though we don't know. Oh, okay.
Yeah, well, okay, so if they had a federal trademark registration, it would be proper. But if they did not, it's improper. It's actually illegal to use the encircle R notation without a federal trademark registration.
And 4B is okay, acceptable?
Yeah, you can use the TM without needing a registration. All right, so we've been talking about building your IP portfolio. We talked about trademarks. What else did we say might be part of an IP portfolio? Copyrights. So let's talk about copyrights a little bit more. Copyright, the definition is an original work of authorship fixed in a tangible medium of expression. And to take that legal language and put it into everyday terms, think about a song. If you have a song floating around in your head, or you just go out and you're humming a tune, or you sing it, you came up with a new song, but you're just singing it, it's just in your head, it's not fixed in anything. As soon as you record that, you record it on whatever you record today, MP3, CDs, whatever, you record it, or you write down the notes on paper, that's recording on a tangible medium of expression paper. So then you have a copyright. And you have a copyright automatically as soon as you do that. You do not have to register it. It's automatic.
Wait, so if you have a copyright written, if you've written a piece of material.
You have a copyright.
Okay.
As long as it's original. If you copied somebody else's book, that's not original, so you don't have a copyright. If you think of a story, you write it down on a piece of paper, you type it, or whatever you do, you have a copyright as soon as you do that.
So
you
someone
have an unpublished
copies,
one, and then if you publish it, like if you put it up on your blog, then you have a published copyright.
so if someone changes the date and claims that theirs was before yours, how do you tell which one is
Well, so
first?
you should have your own evidence of what you came up with, and now you're starting to deviate from. Now you're starting to get it more into almost criminal activity,
right.
because they're committing fraud and making representations that they came up with this before you even said they copied it. So hopefully you'd be able to
Still
prove that.
mail it to yourself, print it out, and mail it to yourself.
Right,
Yeah. Put it up on a blog.
Yeah, is that really true if you put it out on a blog? That's not considered public domain?
No, it's not unless you designate it. You have a copyright in it. People can't just go, I can't just load up somebody else's website and copy paste it onto mine without their permission, or if they say on there, I'm putting this out there for the public domain, they would have a copyright in it.
Because if you just go out and speak, right, if you go to open mic night,
Now,
Just
are
say
you
it.
fixing it in a
That-
tangible
that's
form of expression?
public domain.
Well, open mic night, you're not really fixing it in any tangible,
Exactly.
so you don't have any copyright.
But
If you record it, you turn on your digital voice recorder and record it, now you have some copyright. Now, it depends on the venue. They may say, if you come here and you speak your poetry, you consider it public domain. You can put rules and conditions on it.
that's what turned me into a writer when I performed.
What's that?
Having my stuff stolen at open mic night.
Doesn't mean that people won't steal it, but you have a copyright, and you can enforce your copyright. Issues of fraud and people stealing things, those are really, just because you have protection, just because you lock your front door, doesn't mean that somebody can't break into your house, but they're doing something illegal. Protection is not available for facts, so if you write a fact down, the sky is blue, that's not copyrightable. If you have just an idea, now the expression of that idea, like you have the idea for a story, the expression of that idea would be copyrightable, but the storyline itself may not be. Like Harry Potter, there's a very specific expression of that story, but that does not prevent you from going out and writing your own book about wizards. You can still write a book about wizards. They don't have copyright on wizard stories. Now, if you copy Harry Potter, that would be a violation of their copyright. If you come up with your own story about wizards, that would be your own copyright.
You said your systems and methods aren't protected. What if you're doing like a curriculum or something?
Systems and methods are not, the expression of that may be copyrightable. The actual system and method and technique might actually be subject to patent protection.
Okay, I guess I'm not understanding what you're saying. So are you saying that a curriculum, the document part of the curriculum is protected, but people can copy your curriculum?
They can't copy it. Copyright covers.
But I mean, they can use your curriculum without.
No, they can't. They can't use it because then they'd be copying it.
Okay, so as long as you have it written
But
down,
they can come up with their own curriculum.
that's very similar to yours. And
Now they can't base it off of that because then it's a derivative work.
Okay.
But it doesn't prevent them from coming up with their own curriculum that may have similar functional components. Now those functional components, if those functional components are unique, you may be able to apply for patent protection, especially if you embody it in a software product.
Patent versus copyright.
Yeah, so if anybody has questions about patents, we're not talking about patents today, but I'm a patent attorney. That's what close to 100% of my practice is. So if you do have any questions on patents, feel free to contact me or ask me after class. I'd be happy to talk to you about that.
Yeah, with sound, with copyright, so if you're playing something and you record it into a sound format, is it the performance or is it the song that's copyrighted?
It's going to be an audio recording.
So
It's
it's
going to be copyrightable. You can actually register a copyright for the audio recording. The performance of that, so now you have copyright for that song, so nobody else can go out and perform it. They can't modify your song, they can't take pieces of it and put it into their own song. There's certain limitations on that. Fair use applies, but they generally can't go out. Well, I really like the chorus line on this song that you recorded. I'm going to go put it into my own song. They also can't, now that they've heard your song, go out and sing your song without violating your copyright.
since the actual song itself is not just the performance of it.
Yeah, you'd actually register the audio recording with the Copyright Office. If you registered it, you don't have to. There's certain reasons that you want to, but you don't have to. You have copyright automatically.
Do you know what the limits are